Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we have spent the last few months talking about all the state legislators around the country essentially just throwing a big old middle finger at not only the Second Amendment, but the United States Supreme Court, in particular, their most recent ruling in New York Pistol and Rifle Association v. Bruen. It has many of us clamoring, what the hell can we do about it? And we did this video right here, which unfortunately did not have a lot of good news about things we could do outside of the voter's booth to deal with some of these politicians who continuously write unconstitutional legislation. But perhaps the tide is turning. Perhaps the United States Supreme Court has said, you know what? Enough of this, and they're finally starting to call some of these troubling kids to the principal's office. So today, we're going to talk about some really important developments. So let's spend a few minutes and talk about, has the state of New York officially pissed off the Supreme Court? Okay, so the case we're talking about today, and this is not the first time we've talked about this case, is Antonyuk v. Hochul. This is a case that challenges the implementation of New York's Concealed Carry Improvement Act, or which is essentially a big old FU to the United States Supreme Court following their holdings in Bruen. Now, here is the huge development, okay? The huge development is at the request of one of the plaintiffs, the Gun Owners of America, a fine organization continuously fighting for your Second Amendment rights, the United States Supreme Court, that's right, the United States Supreme Court has ordered the state of New York to file a memorandum or position paper with the United States Supreme Court no later than January 3rd, explaining why the Supreme Court should not vacate the Second Circuit Court of Appeals rulings as it related to the injunction or temporary restraining order on this legislation. Okay, let me say that again so you understand that. The United States Supreme Court is basically saying, New York, hey, New York, you need to put up or shut up no later than January 3rd and explain to us why we shouldn't reverse what the Second Circuit did. What exactly did the Second Circuit do? Well, this is what we're going to do. So we're going to kind of break this down in real simple English, use some little graphics here to help you understand. Let's go back in our time machine here and talk about how we got to this point, okay? As we know, this past summer, there was a concealed carry law in New York, represented by this figure right here, which was brought before the United States Supreme Court and soundly rejected, thus striking down all of New York's rather oppressive and ridiculous concealed carry laws, thus labeling this law as a loser. Now, of course, never being a good loser, that particular governor decided, you know, I'm going to go back to my state capital in Albany, and we're going to draft a new law that is actually going to be more oppressive, more ridiculous, and more violative of our citizens' Second Amendment rights. And we're going to do it with a big old smile on our face and a middle finger to the Supreme Court. And actually, just for jokes, let's call it the Concealed Carry Improvement Act of 2022. And hey, if we can spend billions and billions of dollars and call it the Inflation Reduction Act, why can't we call this the Concealed Carry Improvement Act? Now, the issuance and the passing of this law, which actually took all of New York's crazy laws and doubled and tripled down and actually made them more restrictive than they previously were, led to a lawsuit, the one we're talking about today, called Antonyuk v. Hochul. Now, that case was brought up to the Court of Appeals for the Northern District of New York before the Honorable Judge Suddaby, and there was a motion for a temporary restraining order against implementation of this law brought by Gun Owners of America and Mr. Antonyuk, the plaintiff here. And Judge Suddaby, in a 184-page opinion, very well-drafted opinion, he issued that temporary restraining order. So essentially, the implementation of New York's crazy Concealed Carry Improvement Act was put on pause by Judge Suddaby in the Court of Appeals, Northern District of New York. Okay, so now the law is on a temporary restraining order. In some jurisdictions, we call them injunctions. It's basically the same thing. It is a big, gigantic pause button on the implementation of the law. But wait, no. New York was going to have nothing of that. They immediately stampeded up to the Second Circuit Court of Appeals asking the Second Circuit Court of Appeals to reverse Judge Suddaby's temporary restraining order against the implementation of this law. The Second Circuit, in a 1.5-page opinion, scribbled essentially on a cocktail napkin, did in fact grant New York's motion, lifted the temporary restraining order that was issued by Judge Suddaby, and allowed the Concealed Carry Improvement Act to go into effect, thus oppressing all New York citizens' Second Amendment rights. Now, what's happened is the gun owners of America and Mr. Antonyuk have gone to the United States Supreme Court and said, hey, the Second Circuit has totally acted out of character here. They have no legal authority to do it, and we want you to order the state of New York to put up or shut up. And that is exactly what the United States Supreme Court has done. Why is this important? Well, it's not only important to all of the citizens in New York who for many, many decades now have not been able to enjoy their God-given rights, but it's also important to all of these other jurisdictions around the country. Illinois, New Jersey, Michigan, hey, a couple right out here, Washington and Oregon also, that where we're seeing these state legislatures essentially thumb their nose, throw a middle finger at the United States Supreme Court, and pass laws saying, hey, we're going to do it anyways. And what the tact has been for many of these on the gun-grabbing left, unfortunately, is even if these laws are unconstitutional, hey, it's going to take 2 or 3 years to get through the system, and we can inflict our misery on the citizenry in that time. What the United States Supreme Court is possibly saying, and possibly establishing a new precedent, is no, 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 no. You see, if you're going to intentionally thumb your nose at rather clear precedent, we are going to call you to the principal's office. We are going to make you put up or shut up. And if you cannot, we're going to vacate the rulings of those lower courts. And so what's at stake here, coming January 3rd of 2023, not only for New Yorkers, but people all around the country, is the Supreme Court going to send a clear message to all of these states that, you know what, this crap is no longer allowed. So once again, the case is Antonyuk v. Hochul. We'll put the links for it down below. And the state of New York has been ordered by the United States Supreme Court to issue a memorandum of authorities explaining why the Second Circuit had lawful authority to do what they did no later than January 3rd. Now, we're going to geek out here for a moment, and this is going to kind of get deep into the woods. When these matters are ordered, each justice is assigned to basically oversee one of these circuit courts. And in this case, the Second Circuit is supervised by Justice Sotomayor. Now, I know some of you are rolling your eyes here and saying, well, she is a liberal justice who likely is going to rubber stamp what the Second Circuit has done. And that is entirely possible when you look at Justice Sotomayor's rulings on other Second Amendment cases. However, and this is an important however, if Justice Sotomayor rejects the plaintiff's request, the plaintiffs have the right under Supreme Court rules to then petition any other justice to do a similar review and to make a similar order to the state of New York. Can you think of any other justice who might be very interested in taking this up with the state of New York? So even if this is upheld, and when I say upheld is even if the Second Circuit's lifting of the stay, it's like a double negative there, but even if the Second Circuit's ruling is upheld, it does not mean that the plaintiffs in this case cannot go to another justice of the Supreme Court for a do-over. We will keep you posted about this because this has the ability to have very long-lasting and very beneficial impacts to any of this gun-grabbing legislation we see around the country. In the meantime, if you guys got any questions about this or anything else related to your Second Amendment rights, you know the drill. You can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.